You can, yeah. Yeah.
I think you know, Brian.
I was thinking 75 minutes might be part, but you know, it kind of depends on how many questions you get from people tonight and some of those things. So once I give it over to you, you'll be ready to go. So, and thank you again, gentlemen, for being here. Test, check. Hear me okay? Are you ready to go? Okay. You can be on, so to speak. There may be a few more that will come in, but I think we'll get started. Thank you for joining this evening for this session in estate planning. I'm Tom Hoy. I'm a member of the finance ministry here at Spirit of Peace. 10 years ago, I attended a estate planning session put on by a local college that identified what sort of assets one could give to heirs that would minimize or eliminate taxes to heirs or an estate, and benefit nonprofit organizations as well. One of the few things I probably remember, because I have to go back like many of us do and look at my notes, but for instance, money given from a 401k to heirs may create a tax liability. So possibly giving your heirs money that's not tied to a 401k may benefit them, or there are ways to work around those taxes. But this can be kind of a barrel of snakes when it comes to taxation and some of those things. I'd like to thank my fellow finance ministry members tonight for their work on this event. That would include Mary D. Young, Ben Art, Verge Anderson, John Volbrecht, and of course, Pastor Charles. And I'd like to especially thank Leanne Minister, our Director of Congregational Life, for her organizational assistance and doing so many of the little details that were part of the chain of getting this done. Also, I'd like to thank our AV crew tonight, Walt Hummel and Kim James. The event is being recorded so that others who are not able to be here this evening can benefit from it. I want to just briefly mention that in June of this year, Spirit of Peace, through the work of the Finance Committee, created an endowment. That was done in a way to provide for future fiscal growth for our church, and to give people one of several avenues of consideration of a gift if you choose to do so. An endowment is an ongoing asset where you can make a 4% draw from investment growth for expenditures, typically on an annual basis. As the fund grows through current and future gifts, it can increasingly provide ongoing financial support for Spirit of Peace Church. We will be able to make more of a ministry impact because of the visionary generosity of people. Copies of our endowment policy statement explaining our endowment governance, gifting, investing, and spending policy are available on the back table. You're welcome to take one if you would like to. The endowment is one of many ways donors may consider a legacy gift benefiting our church through a will or trust. Our presenters tonight are both attorneys who specialize in estate planning, and they are both accredited estate planners. Let me introduce them through a short reading about each. First of all, Brian Kirby is a person that practices in the areas of corporate and business law, mergers and acquisitions, criminal, and trusts and estates. Brian has assisted hundreds of individuals from young entrepreneurs to in business succession planning, estate and trust planning, guardianship and conservatorship, and employment matters. And also John Heisler. John is from Core Trust, which happens to be the bank that Spirit of Peace uses. And so we thought it was appropriate that because we have our loan and we have other accounts with Core Trust, we asked him if he would assist us in this matter. John Heisler is the Core Trust Bank Wealth Management Senior Vice President. He has been practicing law and managing or working for various Sioux Falls wealth management groups and trust departments for over 30 years. As the leader of Core Trust's Wealth Management Division, John oversees and manages various areas, including trust, financial planning, retirement planning, and investment services. Plus, John has been recognized as an accredited estate planner. We're pleased to have both of these gentlemen with us this evening. Thank you so much for coming. Feel free to make notes in your book, and I'm sure that there will be time for questions that you have. And thank you all for coming. Gentlemen.
Could you get me one of those manuals, the things that we handed out? Sure. So I want to go through it. Good evening, folks. I'm Brian Kirby, and John Heisler have been introduced here. Basically, what we want to do tonight is to kind of tell you about the overview of estate planning. When, our goal here is not to answer all your problems. Our goal here is to kind of address what's been itching in your gut. The reason you're here is that you want to do some estate planning or you want to learn about it. And that's our role here, is to kind of explain what estate planning is, the various things that we can do. And John and I are going to kind of tag team this thing. And it's kind of funny because John used to practice law with me, and probably 20 years ago we gave estate planning speeches very similar to this. And so if you have any questions, raise your hand. I've got not the best ears, but if you've got a question, I don't like to wait till the end for all the questions because everybody forgot what we're talking about anyway. So if you've got a question that's pertinent to what we're talking about, then we'll go through it. Now, what you have in front of you, and free to take this with you, it has various things. On the left side is our bios, John and my our biographies. On the left side is basically a printout of what we're going to go through tonight. So if you've got a pen, write notes down. These are yours to keep. Behind that is just further explanations of what estate planning is and what you need to do. Like I said, if you've got any questions, we'll go from there. But what I'm going to do is I'm going to be waving to Leanne to change the pages as we go through it, okay? Let's try the first one here. All right, basically what I just said, I'm just talking. I'm not giving you any legal advice. This is something to spark what's in your head, hit what's in your gut to figure out what you want to do, or maybe hopefully answer some questions that you have. Next one. All right. What is, and John will interrupt if he's got some things to say, and I'll do the same. Most people think estate planning is, what do I do when I die? I've got a plan for my death. I've got a plan for what's going to happen to my assets or my kids, or everything from if you have farmland to a business to investments to your cat and your dog. And it's more than that. It's also planning for incapacity. You've got a 100% chance of dying, but you've got about a 1 in 6 chance of being incapacitated for longer than 10 years during your life. And that means that if you have dementia or whatever, you need to have things set up so your estate plan doesn't miss a beat. If you've got family interests, if you've got businesses, if you've got anything that you need to do, you need to set aside somebody that can speak for you if you're not able to. When you do estate planning, it's a written set of instructions. Who gets what, where, when, who doesn't get anything. And a lot of times people will think, I can't disinherit. Disinheriting means that somebody's not getting something. That's not always a bad thing. It could be a bad thing if somebody's in jail or somebody has a lot of legal problems where if you gave them money, that it would automatically go to the creditors, or if they are currently getting Medicaid. If you give them money, then it's sucked up through that. You don't want to do that. But it's also kind of a good thing, too, because maybe some of your kids have 20 times more than what you're worth, and they don't need the money. Or you might have a child that has special needs. that you want to plan for them. The other thing is hedging ascertainable risks. That's what I just talked about. You have Alzheimer's in your family or something like that, and you want to make sure that you're taken care of. You've got business interests. I've got a lot of clients that have family businesses, and what's going to happen? Let's say you've got a family business that makes widgets, but you've got, say you have 4 kids. 2 are in the business, 2 are not in the business. When you die, possibly the 2 kids that are in the business get the business. What do the other kids get? Do they get the investments? Do they get farmland or whatever? Those are the things that you want to think about when you do estate planning. And then also it's a framework for the future. I've kind of touched on that. What's going to happen long after you're gone? You turn the next page, Leanne. Kind of touched on this as well. The objectives here is to make your property go where you want it to. If somebody's going to be disinherited, or you might have a certain situation where you have 5 kids and it might be 20-20-20, or if you've got a family business, somebody might get 30% and so on. And those are the things that you have to realize. And what's more important is tonight or tomorrow you say, okay, this is what I'm going to do. It's not irrevocable for the most part. If you do an estate plan, you can change it. You know, I think my record is like 16 amendments because the family went through evolutions. At first he hated lawyers, then he started liking me, then he didn't like one of the kids, and then he started loving the kid, and you know, it follows. Your estate plan should be a current reflection of what you want to have done. Minimizing taxes. Right now, we have an $11.7 million federal exemption, which there's no federal estate tax for $11.7 million, or about $24 million per couple. They're thinking right now of knocking that down to 6. I don't know if that's going to happen, but those are things you have to look at. In 1989 or 1988, 89, we used to have the South Dakota inheritance tax. This is one of the selling points of the state, is that very low tax base. You pay sales tax and you pay real estate tax. There's no inheritance tax, there's no estate tax. It's probably always one of the top 2 situs or places in the country to have a trust. And it always goes back and forth between Nevada and South Dakota.
And no
so
income
that's
taxes.
Why you, I'm sorry?
And no income taxes either.
Yes, yes. And the guy that Nevada always gets up there, because Steve Oceans is from Nevada, so right. He likes to prog it, but it's true. Protect the fruits of your labor. You've worked hard for what you've accomplished. You've worked hard for what you've amassed. And 90%, as you'll see in here, 90% of people don't have an estate plan. Why do you think they don't have an estate plan? What's the main reason? Anybody? I'm sorry? They just never got around to doing it. Right, never got around doing it. The one that I hear is fear of their own mortality. They don't want to think about dying. They don't want to think that, hell, I'm gonna go. They also think it's complicated. And it's always easy to procrastinate, push something like that off. I don't think any of my clients think, oh, should we go to Valley Fair, go see a Kirby and talk about how we're gonna die? You know, it's not a fun event, but it's incredibly worthwhile. I mean, you look at people like Prince. He died without a will. I mean, how do you do that? He had 50 lawyers around him. And he had estate tax. Originally, the state of Minnesota said his estate tax was like $700 million. And then they got real, and it's down. But he never had an estate plan. So many, you read about famous people all the time that don't have an estate plan. They got a lot to lose, and so do you. What you want to have happen. It also, estate plans prevent the estate from stepping in and determining what's right for you. If you die with a will, you die what's called testate. You died with the will, and they follow the will. If you don't have a will, South Dakota has a statute called the Intestate Succession Statutes. If you die, let's say you die and you have a spouse and you have kids, first marriage, you die, everything goes to the spouse. Let's say you die and it's your second marriage, the original spouse gets the first 100,000, splits the rest. And that may not be what you want. In addition, if you had a post-nup or a prenup, things like that, you have to be aware of that. Also, as Tom was indicating, if you die without a will, there's no provision in the code for charitable giving. There's no provision in the code to give money to this church or to Boy Scouts or whatever you want to do. So you can't have that fallback position if you want to have things done right.
Brian,
Nick?
hold on. Just one comment here. You know, that first statement, make property go where and when. The when is real important for a lot of families because you have kids and they have, they're all different. Some of them very responsible, some of them not so responsible. I mean, my family included. And some kids manage money well, some kids don't. So within your plan, you can basically set it up so that, you know, maybe the ones that are more responsible might get the money all at once or over 2 or 3 different time periods. And maybe there's one that couldn't, I mean, if they have it in their hand, it's going to be spent. So you might put that in a trust for them so that the trust pays them out money every year so that they have enough to live, you know. So it can be really important, and you can put any of that stuff in your estate plan if you need people treated differently because of circumstances, not because you like one better than the other, although that could happen, but really it's because of their needs. So you can be pretty detailed in how you do those types of things.
Okay, Leanne, next page. All right, now, John and I created this, I think I created this in 1990, because things don't change. You know, the laws change, tax laws change, how you do your estate plan, and I've modified it over the times. This is basically the same thing that I've always done, because it's sound and it's true. The way you dispose of your assets, and we're going to go through each of these. First thing is to do nothing. I don't think you'd be here if that was your choice. You know, I always used to call it the Archie Bunker method, just, you guys figure it out. Or a lot of my farming and ranching clients, there's nothing more important, I was told by a farmer, than dirt. I mean, that's their whole life. But they don't think about what's going to happen. And you get ugly fights. I'm sure many of you have been involved or have seen other families get pretty ugly after mom and dad die about who's getting what and so on. You know, I'm an Irish family, and when my mom died, I thought we were going to have I thought, oh, geez, I've been doing this forever. We're going to have a big battle. But it was great. You know, I was kind of like the lawyer of the group, even though I'm the youngest. But the way my mom did it is before my dad died in 2003, mom died in 2017, and before she died, she called him. Is there something in the house that you want? And it might be worthwhile, and it might not be. And she put a little Post-it note. She said, you're at the office, bring some Post-it notes when you see me. And she put Brian on something or Lynn on something. And everybody knew what everybody was going to get. And so when mom died after the grieving and all that kind of stuff, and everybody knew. So it went surprisingly smooth from a family of Irish people. I was pretty shocked, actually. So do nothing is not one of your issues. The next way people dispose of assets is through wills. Next way, and we're going to go through each of these. Joint tenancy, contracts, gifts, and trusts. Next page, please.
One quick question.
Go back one.
Or not a question, but the thing to keep in mind as we go through all of these, every one of those, is something we're going to talk about is how you title your assets. You know, who owns them, how you title them, whether it's a bank account or real estate, your home, brokerage account, whatever that might be. However you title it will determine how it's going to be passed out after you die. And we'll go into that in a little more detail, but keep that word title in your brain and in your head, because it's very important for every one of these things. Go ahead, Leanne.
Okay. All right, as I said, 90%, I can't jump ahead of myself here, 90% of the people don't have estate plans. They don't get around to it. Thoughts of their own mortality. A lot of my clients are like, they can't pull the trigger because they don't want to upset somebody in the family. Well, you know what? You guys are the parents. You guys tell your kids what they're going to get. I'm not saying to sit around at Thanksgiving and say, all right, Jimmy, you're getting 20%, you're not getting anything, you're getting this. That probably wouldn't go over well at Thanksgiving. But the point is that you guys are the parents. And if you have parents, kind of chime them in that we may need to get something done. But you're in charge. You determine how it's done. And again, it's not irrevocable. You can change your mind. But I always tell people it's kind of a morbid thought. When you do estate planning, plan on dying the next day. I want you to make sure that you're satisfied and that you're concrete in your decision for now. Next page, please. Basically, wills, you're telling a story of who's getting what. You say, I, Brian Kirby, this is my last will. And upon my death, I've got 2 daughters. And upon my death, I want this person to run my estate, which is the personal representative. My daughters are older now, then they each get half. Unless they make me mad, then I'll switch it around a little. I'm just kidding. But when you get into the wills, it's essentially telling a story from beginning to end on who's going to get it. And if you have a special needs child, then it kind of complicates things that John will talk about. You might have to have a trust set aside for them if they are on SSI, or if they're on Medicaid or Title 19, things like that. And there are trusts that you can set up that allows your son or daughter or brother or sister or whatever to get the luxuries of life and not make them ineligible for Medicare or Medicaid, excuse me. The next way, if we go to the next one, joint tenancy, and this is what John was talking about. Joint tenancy is ownership by 2 or more people. If you have a couple, and I'm sure there are many couples here, Bob and Jane, they name each other as joint tenancy, so if Bob dies, it goes to Jane. If Jane dies, it goes to Bob. But that doesn't alleviate the point of doing estate planning. Why? What happens to couples sometimes when they travel? They die together, right? So if you have a joint tenancy and they're both gone, then you got a problem. That doesn't mean that you don't do estate planning. And maybe, John, you've got some more.
Yeah, so the word I just mentioned before is title, right? So if you go to the wills, a lot of people think if I have a will drawn up and signed, that takes care of everything, right? I mean, it's my will. I said what I want to have done with my assets, who gets them, when they get them. But your will only controls property that's in your name alone. My will would only control what's in John Heisler's name alone. If my wife and I own our house jointly with right of survivorship and joint tenancy, our will doesn't determine where that goes until one of us dies. So your will might say one thing, and the way you have your property titled might be another. Let me give just a quick example. Back when Brian and I were practicing together, I had a widowed husband. He had 4 daughters. 1 lived in Sioux Falls, 3 lived outside the state of South Dakota. The man had some health problems, so he had his daughter that lived in Sioux Falls put on his bank accounts so that she could help him pay bills, do whatever. And he died. Well, he had the 1 daughter in Sioux Falls as a joint owner. The other 3 daughters were not joint owners. His will said, when I die, split it equally between my 4 daughters. When he died, all of his property was owned jointly with 1 daughter. The will doesn't control that. The way it was titled was joint, so it went to the 1 daughter. And you might think, well, sisters, they're all close, they like each other, they love each other. Well, the 1 daughter in Sioux Falls said, I took care of Dad, I'm keeping his assets. Just a quick example, and it wasn't even that much money, but they fought in a court of law over the assets, and they pretty much spent most of it on attorney's fees. And the really sad part of it is that those sisters never got along again, and They probably didn't have Christmases together or Thanksgiving, that type of thing. I just tell you that story because it's just an example of if you don't coordinate how your property is titled with your estate plan, whether it's a will, joint tenancy, a trust, your 401k with named beneficiaries, we'll talk about all that stuff. But if it's not coordinated so that they match each other and it's what you want to happen, then something opposite might happen to what you originally intended it to do. So just keep that in mind. Whoever you're working with as an estate planner, whether you're working with Brian or you have your own attorney, they're going to want to know how's your property titled. So when you do your estate plan, make sure you bring that with you. Yeah?
Are you going to talk about what creates probate versus
Yep.
not in your presentation?
Yes.
Yep.
Yes.
Yep.
Yes. And that's, as John pointed out, that's an important part of your estate plan, and we're going to talk about in the ownership when you use trusts and things like that. And one of the things, I'll jump ahead, when you have a durable power of attorney that we're talking about and you need help from one of your kids, name a durable power agent, give them limited power to help pay bills and so on. You give them authority to deal with it, not ownership. Because when their name is durable power agent, they're essentially a fiduciary. They're just supposed to help you pay bills. They don't own it. And the other issue I bring up, if you name something as a joint tenant, they can take all the money out if they want. And the other thing is, they hit a school bus and get sued, they could go after that account. You may have the argument of origination, they call it. In other words, that's my money, it's just helping out, but why get into that problem? So if you get into a situation where you have joint tenancy, make sure, as he said, that you line it up with your estate plan and don't give anybody ownership if you don't want them to have to do it. And the big issue that I have backing up is, again, you're the parents. Your job is to keep your kids from fighting. And the way you keep your kids from fighting is clear, concise instructions in the estate plan. Everybody knows where it's going. And depending on the relationship with your family, say, this is what I'm going to do. 99% of the time, everybody gets everything equally, usually. Tell them that. And so when the time comes, then you don't have these issues.
One other point, Brian, on the joint tenancy, sometimes your estate plan can be multiple things. Like it might make sense for a husband and wife to own property jointly. It might. But what I see a lot of times is a spouse dies, then the surviving spouse puts his children on as joint owners. And that could create a problem like I just talked about. Or if your kids have creditor problems, those creditors now have access to those jointly owned assets. So you kind of got to be careful.
Give them authorization through a durable power of attorney or have them go to your bank, have them sign in as an authorized signer. Don't give them ownership. Next page, please. John will dig into this a little more than I will. Basically, contracts are an agreement by one for the benefit of another. And it is between you and whatever insurance company, you and your employer, and so on, and that tells who's going to have it. So if you have a 401k or an IRA that has a beneficiary designation, that's outside of probate. You're talking about probate. And let me jump on that a little before we get into this. What's the difference? What is probate? It's a Latin derivative of a term that means proof of the will. When you die without a will, that's intestate. You still have to probate it. You nominate somebody that's called the personal representative, or it used to be called the executor. It's called the personal representative now. That is the person that speaks on behalf of the deceased person. And when you go through probate, people think, oh, I don't want to go through probate. I think it's a godsend because it protects those that need protection, the deceased person. When you look at the Argus Leader, you'll see these estate notices. You ever see those? Estate notices says Brian Kirby has died. You have 4 months from the first date of this publication to file a proof of claim with the court or the probate court where it's filed, or your claim is barred. That would be like for credit cards, ambulance services, things like that. And I don't know how many credit card companies I've trumped because they show up 8 months later. We did it, you're out. You don't get any money. And that protects people from getting ripped off. because it's pretty easy to file a claim against somebody that's deceased. Oh, I did some car work for him 15 years ago and he owes me 10 grand. Where's your proof of claim? And the personal representative is there to protect the decedent and to work for the beneficiaries. You get into battles with it. And so either you die without a will or you die with a will, you're still going through probate. If you don't have any assets or all the assets are held in contracts, then you might not have a probate. Or if you have $50,000 or less, that's called a summary administration. You just file an affidavit and that might be used to transfer a bank account or something like that. But if you've got more than 50, you do a probate, and there's different levels of probate. When we first started practicing law, we had to trudge our way into every judge's chamber and have them sign off. Then they came up with the Uniform Probate Code, which is when people die, usually it's called independent administration. We never see a judge. We just see the clerk, and we file it. We file all the stuff, and you don't have to worry about it, and it's quick. And as long as everybody agrees on what's going on. If there's a fight, then it gets into formal probate and stuff like that. Does that answer your question?
Well, you said basically you're given 4 months to file your proof of.
The creditors, once you file that notice.
Right, so in what circumstances might a probate activity go for, I've heard of going as long as a year or 2. What might preclude that?
I've got one now where my client died a couple years ago. He was a prolific big game hunter. We had to have an auction. Some of the things that he had, we couldn't sell. Like he had way back when it was legal, he had elephant horns or tusks, and he had an alligator and all this kind of stuff. And then he had some other assets that we had to sell, and we had to put it up for auction. We had to sell it and so on. Or if there's a battle, somebody like he said, I'm supposed to get this money. I had one case that it turned out great. Lady died. Her caretaker, who was just some lady that helped her out, magically came up with this holographic will, which is a handwritten will. We knew it was fake from day one. We battled it out. She finally withdrew it, and now we're going through all this probate stuff, selling stuff, contacting heirs, paying bills, and so on. Another case I had, dad died. Mom was in a nursing home. The son and the daughter thought mom had nursing home insurance. Well, I have to notify, when someone dies, I have to file a notice to the Department of Social Services to determine whether they had Title 19, public assistance. Third time in 35 years, I get a bill back for $250,000. It's like, everybody's, what happened there? Well, Dad didn't want to pay the nursing home insurance anymore, and they got dinged. So my biggest creditor is the state. And we have to pay off, there's not enough to pay it off, but we're paying off the claim from the Department of Social Services. So when you start a probate, you're putting the world on notice that Brian Kirby died. Any creditors want to come from that first date of publication in the county of the decedent. I can't file it in, I'm in Canada. You got to file it in Minnehaha County or Lincoln County or Hughes or wherever they died, and they've got 4 months from that first date. And it's published 4 times, and if they don't file it, they're out.
9 times out of 10, there's not any issues, and the probate goes through very smoothly. It's, you might have read articles about in other states where probates go on for 2, 3, 5, 10 years, like a California or New York. South Dakota, you just don't see that very often. But if it does extend longer, like Brian said, it's usually an asset valuation issue, like a family business where you have to get it valued. It might be difficult. Or you might have a kind of a unique asset that you have to find an appraiser somewhere that knows how to do that, and that may take longer. Or a court contest where beneficiaries are arguing over what they should be getting, or what I've seen a lot of times is that one of the kids, or maybe just a close friend, while the person that became deceased was ill, they placed some undue influence on them and got them to change their will or their estate plan. And in that case, the beneficiaries might sue and then there's a court case, and that's, most of the time, that's when it takes longer than that, probably 6 to 8 month term for a probate. Yep.
Gentlemen, I want to say when you get a question, you might want to repeat it so everybody can hear what the question was.
Sure.
Repeat what?
Repeat the question.
Oh, okay, all right. Should I start from the beginning?
I'm not wandering around aimlessly. I was hoping we could get your mics a little bit. Mr. Kirby, yours is a little bit hot, so it's getting some echo and it's a little harder to understand you. Because it's almost working.
Is this not working, or?
It's working fine. This is a little too hot.
Okay.
Keep talking.
Yes.
Am I correct? If there is a will, there is not going to be a probate. Is that correct?
No, either you have a will or you don't have a will, you still have probate. You either have probate in intestate succession. In other words, intestate succession means that you died without a will. You still have to probate it if it's over a certain value.
If it's over a certain dollar.
Right. If it's, you want to do the switch, or?
Yeah, we'll just give a little switch and see if,
Am I cutting out?
I'm not sure, but let's just try this to see if this helps.
Is this better? A little better? You like that one more? This one? All right. Can you turn up the volume at all? Does that help?
Lower it on your tie. Is mine okay?
How's that? Better?
Yeah.
Okay. So if I die and I don't have a will, and there's a dollar value, I still have to go through probate. It's just independent intestate succession. Somebody in the statute would be appointed as a personal representative, and somebody would help wrap up the estate. If you die with a will, you have to go through probate. That's what it's for. And probate is not evil. Probate protects you if you're deceased. Probate protects people. It protects the creditors to make sure they get paid. It protects the beneficiaries to make sure that they get what they're supposed to. And it protects the decedent. I don't know if I'm... It protects the decedent to make sure that he's getting what he's supposed to. Do you follow me?
Brian, I think the thing to know, again,
Okay, so you make a will, and you name an executor of the will. Okay, and so if this is not that person's job to see that all the bills are paid and all that kind of stuff. I mean, and in the will, you designate who gets what and how much and all that kind of stuff.
I don't know what's causing the feedback here. All right, let me give you an example. You die. You name your daughter, I'll call her Betty, calls me. All right, let's call him Bob. Bob calls me and said, my mom died. I've got to start a probate. And he comes in and sees me. And we look at your will. And we go through it. And it says, Bob's the personal representative. Then I give him a list of stuff he needs to do. I tell Bob, I say, I need you to look at all the assets, give me a list of all the accounts, where they're held, how much is in it, and I need to file the original will with the probate system. I file it with the court, and I get what's called back letters of testamentary, which is Bob, your son's license to do what he needs to do. He has one piece of paper that says Minnehaha County, as the will has appointed Bob as the personal representative of Jane Smith. And so in order for him to do what I need him to do, he needs to have this piece of paper. So if he goes over to Court Trust and says, I need to see what's in the bank account of my mom, and I need to transfer it into an estate account. If Bob just shows up without that paper, John's going to say, who are you? We're not giving you any information. So when you start the probate and you have a personal representative appointed, that gives him the legal authority to act on your behalf. You follow me? Does everybody follow me? And so when he does that, then he comes back and he says, here's all the assets, here's all the debts, and if there's money available in the account, or there's money available in the estate, we send out notices to the beneficiaries. Hey, these are the bills that we're going to pay. These are the bills that we're not going to pay. This is what's left. And under the will, this is who gets what. That's what probate is. Then we give, yes, ma'am.
What if you have code?
I'm sorry?
What if you have
Code? Under the South Dakota Code? Co-executor. You.
one executor do it all and not let the other person know they're an executor?
I'm not a big, I have, in my estate plans, I say, if we have co-executors, like a lot of times I'll have co-trustees or co-executors with core trusts because they handle all the financial stuff and you handle all the personal family stuff. But if you have co-executors, a lot of times, if they have to act jointly, they got to sign everything twice.
Okay, but can one person do all kinds of things without the other person even knowing they're a co-executor?
Yeah.
The lawyer has to contact both executors?
I think, number one, if I'm the attorney and they come in and they say we got co-executors, I'm going to notify the other executor or the personal representative. Does that answer your question?
What if they didn't?
Then we got an issue. Because if the will says they will act jointly, then they have to be both in. The will may say, I appoint John and Brian as my co-personal representative. They may act jointly or independently. And I suppose that gets into a family trust issue. You know, if I'm too busy doing my stuff. John, you handle it. I'm not going to have to worry about it.
But if they're not aware, they don't have that choice.
Yeah, if they're co-executors, then they probably need to be made aware. Co-personal rep.
Continue to do things when one person doesn't even know they're the co-executor.
They probably do now, right? Yeah, yeah. If they were appointed as co-personal representatives of an estate, it's incumbent upon the lawyer to let them know. Okay?
Let me comment on that. So I get calls every day from tellers and bankers, and somebody will have died. And the first thing that I ask them for is a copy of the will or the trust, whatever it is that's going to determine where the property goes to. And if there's a co-executor or a co-trustee, and that's all it says, then you have to have both people authorize anything you do with that asset. You have to have both signatures. Now, if the will or the trust says that they can work independently of one another, then I tell the banker, you can take either one and they can do the business. Does that make sense? So if it doesn't say anything other than John and Brian are the co-personal representatives or co-executors, we both have to sign. And if you don't, that's where you're going to have legal battles.
And that's in the will? That
Yes, yeah, in your will or in your trust. Yep.
That gets back to your estate plan to make sure you've drafted how you want it. That you put if you want them to act. And a lot of times I'll do successors. Brian, if he is unwilling or unable to, then John. If John is unwilling or unable to, then Bob. Because I like to have one person in charge, and that gets to you when you do your estate plan, who can you trust? And if they're unable to, they live out of town, they emotionally can't handle it, or more likely they financially can't handle it, they're not very good with money, you don't want to appoint them in the first place. Does that answer your question? How about you? Everybody? Okay.
Define probate, please. Just define it, probate.
Probate? It's a Latin derivative of a term that means proof of the will. It's the process of verifying, validifying a will and making sure that the contents and the provisions of the will are carried out. And not to confuse you, but if you die without a will, we have the intestate succession laws, which says if you die with a spouse, it all goes to your spouse. If you die and your spouse predeceased you, it all goes to your children of that union. If the children are not around, then it goes to your siblings, your parents. And if your parents aren't around, then it goes to your siblings. And if your siblings aren't around, it goes to your second, third, fourth, fifth cousins. It sets it out in boilerplate form. So if you have a will and it has to be probated, if you have a will and you have $1.50 in your account, they're not going to have a probate. It'd be a summary administration. It's an affidavit that I'm taking over for mom's estate and we're insolvent or there's only $50,000 or less and I'm going to pay these bills off. If there's a will, it's as simple as they come in and see me, I look at the will, same with John, and I tell them what I need to do. I need an inventory of all the assets. I need an inventory of all the expenses. Are we going to disclaim any of them?
Okay, what is that dollar amount that guarantees probate?
If you are 50,000 or more, real estate, if you have everything in IRAs and 401ks, and we'll talk about that, you may not have a probate because that's a contractual issue. That's a beneficiary designation. Okay? All right?
In essence, the way I think about it is your probate, basically, you're just proving up what they had in assets, what they have in expenses, what they have in debts. You pay the expenses and the debts, and then you distribute the assets to whoever you want it to go to. That's kind of the simple version of it. Yeah.
Talking about the contracts we talked about, that's insurance. You've got insurance on your life. You named who the beneficiary is going to be. Annuities, IRAs, retirement plans, and pension funds, I'll turn that over to John.
What if the beneficiaries, husband and wife, they die together?
You have contingent beneficiaries. Like your wife would be your primary beneficiary. If she's not around, the contingent beneficiaries would be all my kids equally. Or
It automatically does that thing. That's not written.
no, got to have that in.
So that goes into the estate plan.
Pretty much any life insurance policy, or an IRA or an annuity or a 401k or a profit sharing plan, they'll ask for the primary beneficiary, and you might name your wife, okay? But if your wife isn't there, you want to name a contingent beneficiary, which might be your kids, and it might be in thirds, or if you have 2 kids, it's split in half. But you want to make sure for your estate plan that any asset that has a named beneficiary, you name a primary and a contingent, always. Otherwise, if you don't name a contingent, in your example, he asked if the husband and wife name each other, and they die in a common car accident, and there's no contingent beneficiary, then it goes to the estate, and then it's probated through your will, which you're maybe trying to avoid in some cases.
And that used to be a problem way back when, because the unified credit exemption was $600,000. And if you had $1 million deal, then you had some federal estate tax and all that kind of stuff.
But one more thing, Brian. So, again, you asked how to avoid probate. So, any of those things, insurance, annuities, IRAs, retirement plans, whether it's 401k, ESOP, profit sharing, where you have a named beneficiary who's alive, those don't go through probate. Jointly owned assets, if the other joint owners are alive, it does not go through probate. And it's not controlled by your will, because that's the title. The title controls. The only thing your will controls is property that's in your own name alone. If it's in a trust, if it's jointly owned, if it has a named beneficiary, none of those assets are probated. Okay?
Now, John can talk about the insurance, annuities, and IRAs, retirement plans, what I basically say, it's a contract between you and someone else. I have X amount in a 401k, or I have X amount in insurance, and it's controlled by the beneficiary designation, who you name. And so you might want to check on that to make sure that it's current. If you are, and in fact, I had a really interesting case a couple of years ago. Lady came and saw me, and she and her husband got divorced. But they were like, because he had some addiction problems, and he went away and he came back, and she said, "Can I live with you and the girls so we kind of still a family even though we're not married anymore?" She said, "Sure, as long as you stay clean." So they went on trips together, and they did this and that and so on. And he had an insurance policy, and he went in and said, "I know I'm divorced, but this is my," everybody thought they were still married, but they were divorced, and said, "She's the mother of my kids. If something happens to me, I want her to have the insurance." And so she went into this agent and said, "I want to re-up and say my ex-spouse is my beneficiary." Well, there's a state law that says when you get divorced, because people forget, you get divorced, "Oh, I forgot she's on my policy," it's null and void unless you can prove otherwise. And so there was no fight from the insurance company. They just said, "Hey, so we're not paying twice. We need to make sure that the court rules that the ex-spouse survivor is the beneficiary of this policy." And we went through it, and the insurance company was cool with it, and they said, "We just need an order from the court." And we had a guardian appointed for the kids to question the kids. Is this how it went? And so on. So it went well. And it was ironic because there was a case out of Rapid City, identical circumstance. I couldn't believe it. It was right on point. And so the point here is that you need to make sure that your beneficiary designations are correct. And just check them. I'm sure your insurance agent calls you to have a checkup and make sure that is the way you want it. Any questions on contracts? The other thing to talk about is prenuptial and post-nuptial agreements. A prenuptial agreement is an agreement that you make with somebody before you get married. It could be a first marriage, it could be a sixth marriage. And it basically says, these are my assets, those are your assets. If we get divorced, I take my assets, you take your assets, unless we commingle something. A post-nuptial agreement is done after you get married. And I have a lot of those with second marriages. They love each other, but they're saying, "Hey, I love you, but I've got responsibilities over here, so do you," and you do a post-nup. And a lot of the businesses that I represent, now that the parents are transitioning the ownership to the kids, some of them require a post-nup. They require it. Why? Because they don't want their kids getting a divorce screwing up the business. And so they do that. It's not that uncommon anymore. Buy-sell agreements. That's if you're in a business, and if you're in a business, you might have insurance to help if one of your partners dies to buy him out, things like that. Now, the only important thing is I would defer to John here is if when you get into IRAs and 401ks, insurance, make sure you know what you're buying. Make sure you know how it works. If we go to the...
Let me touch on that. Tom, you kind of talked about it in your introduction. Because you have a fund here at the church, a charitable fund that you can contribute to, sometimes the best assets to give, if you're going to be charitably inclined and give it to a charitable organization like a church, the best assets to give many times are the 401ks, the profit sharing, the IRAs, because when the assets come out of those, that's when you get taxed. So if you pass those on to the church, there'll never be a tax, okay? Because it's going to a charity. And so a lot of times that's the best type of asset. You can give any kind of asset to a charity or to the church. I'm just telling you, some people have a large percentage of their assets tied up into a retirement plan or an IRA. And you don't have to give it all to them. You can if you want, but you can give part of it to them. But those are all pre-taxed assets, assets that have never been taxed, and you can give those to the charity and then they never get taxed. So that's my pitch for the charities. Yes?
One other thing that bears mentioning is if you're over 70 and a half years old and you have money in a 401k or an IRA, you can transfer that money to the church or a charitable organization without having to have income tax withheld.
Yes. Yep. You're right. You're absolutely right. Yep. That was a law that was put in place not that long ago. And rather than taking your required minimum distribution, the RMD, you could just transfer that amount of the RMD to the charity and it would never be taxed, up to $100,000. That's what you're referring to. That's an annual deal. Yep.
If we could go to the next slide. There we go. Gifting. This is where you might have larger estates and you want to get rid of the assets that you have. If I'm Grandpa Moses up here, I can give every one of you $15,000 this year. If I have my wife next to me, she could give $15,000. So each one of you could get $30,000 per person per calendar year. And what you have to be aware of is it's per calendar year. So let's say you're my 3 daughters, and I give each of you $15,000 on Christmas Day. Merry Christmas. Then on the 30th of December, I give you another $15,000. No, excuse me. I give you $15,000 on Christmas Day. Then January 1st of the next year, I give you $15,000. But you cash both of them in that next year. What's the problem? You've got a gift tax. You've got a gift because it's $15,000 per person per calendar year. So in order for a gift to be completed, the person has to take instance of control over that gift. If you write them a check, they got to cash in that year. You give them land, they should probably file a deed within that year. You give them any kind of an investment, they need to take control over it in that year. And so you give $15,000 per person per year. Yes.
So in your example, I gave a son $15,000 on June 1st. Can I give them $1,000 for Christmas as a gift? And does that $1,000 then become taxable? Or
Legally, yes, but normally parents will buy them lunch. Are you supposed to declare
right.
that? I'm not saying that it's not, but and that's not just for your son. You give $15,000 to your son, his wife, all his
Right,
kids,
right.
all that stuff.
But technically, it's taxable, but
Yes, yes.
Something to keep in mind is that each person can give $15,000 per year per person. So a husband and wife could give $30,000 per child if they wanted to. So if they had 3 children, they could give $90,000 away, and it would never be subject to gift tax.
And it doesn't have to be you can give it to Tom, Dick, and Jerry that you want. I mean, and down there below it, anything you give to the church or qualified charities is not, there's no limit. You want to pay somebody's school expenses, you can do that, a charitable deal. But you don't give the check to them because they'll, whatever. You give it right to USD to pay their tuition, things like that. Everyone here has $11.7 million exemption. They're talking about knocking that down to $6 million. So as a couple, you have $23,400,000. That's an astronomical number. But what that means is that, and they do reverse math on this, I've always hated it. Let's say you die with $20 million. There's a tax bill, but you get a credit for it. So there's no tax. And the federal tax is basically a tax on saying, hey, you really did good during need some money. And the taxes, there's no federal inheritance tax. It's a tax on the assets of the decedents when they die. And so those are kind of up for play right now. Whether they're going to knock them down to $6 million or not, I don't know. Portability, That means everyone here has $11.7 million exemption. When, let's say, my wife is right here and I die, within a certain period of time, she can elect or transfer my election to herself. So she has 24 million. In other words, she can use my exemption. But the problem is, it's only for me. If she marries, she loses that and it goes to the exemption of the person that she marries. You know, that's just something, food for thought.
So the old law was if you don't use it, you lose it. That was the term. So if you both had $11.7 million exemption and I died and for some reason my exemption didn't get used, my spouse couldn't take mine. She couldn't use it. It was gone. Okay? Now with the portability, if that happens, they still allow the surviving spouse to take both exemptions and use it as their own. Now, $24 million, not a lot of us have that issue or that problem, but there are some people that it affects. And if it goes down to $6 million apiece, then it'll be $12 million, not 24. And even 12 doesn't affect a lot of people, but there are people that have that kind of assets out there. So,
Next slide. I'm sorry, I'm having trouble with this microphone. And I'm just going to do the intro and have John, he's the expert on this. This is all he does, is trust work and so on. A trust is a contractual agreement by one for the benefit of another. It tells a story. For instance, I, Brian Kirby, established the Brian Kirby Revocable Living Trust. During this time, I can take assets out, I can put assets in, I can terminate this trust at any time. During my life, I'm in total control. Upon my incapacity, I hereby appoint Core Trust Bank to act as my successor trustee. They are required to provide for my health, education, maintenance, support. Take care of me. I need something, take care of me. Upon my death, they pay all my last illness and funeral expenses, gather all the funds. I've got 2 daughters, and upon my death, the trustee will take care of their health, education, maintenance, support. When they reach a certain age, they get a certain amount. When they reach another certain age, like the one I like, the older I get, the dumber kids are. Now it's at 25, 30, and 35. So when they reach 25, they get the first third of their share. So if you've got 5 kids, I'm the 5th of 5. And my dad bought a car, and by the time I got it, the thing wouldn't start. Why? Because 4 other kids trashed it. And that's kind of my theory with estate planning, with trusts. You have 5 kids, the second dad dies, there's 5 separate accounts. So if the oldest child wants to become a professional student, he's not blowing all the money of all the other people. He just blows his own money. And so when they reach certain ages, at let's say 25, they get the first third of their share. That's fair. I see in life people graduate college, they need a little seed money. 30, they're getting married, they need a little seed money. At 35 or 40, they might have kids. Then when everything is distributed, the trust as to that child ceases.
What's the cost of that trust to the estate?
It depends on what you want to do. It depends on how extensive it is. And if you, when people meet with me, I usually send them a client questionnaire beforehand, so I know everything about them. So I'm not sitting in the room trying to figure out how to spell your third kid's name. I know everything about you when you come in, and it speeds it up, and I'll tell you what I think. And most lawyers that I know, maybe John is heard differently, I charge base fees, just based on this is how much trust costs, this is how much a will costs, and so on. And, you know, and I explain all that. We have diagrams and show you how it works.
Percentage or what?
No, no percentage, just base fee,
Oh,
you know.
and then I had another question. Do you have,
Can you put the mic?
is there anybody that knows how to find people that maybe you've lost their address where they are, and you want to include them in your will?
So you've got some beneficiaries, you don't know where they live?
Yeah.
You can do a skip trace on them, or if somebody knows, if you want to give them assets, you don't know where they live though.
Yeah.
We do that. I can track somebody down.
What is a skip tracing? What is that?
I'm sorry?
What is that?
A skip trace?
Yeah.
That's what PIs use to track people
Oh.
down.
Okay, so they can find them. They don't need a social security number or anything?
That would help. If you have a social security number, a name, so on.
I started asking for social security numbers and they got a little bit offended.
Yeah, that helps, 'cause then they can track them down.
But they,
We do that. We all do that all the time. If I have a client selling a business, we do a skip trace on them, figure
Oh,
out if they're
okay.
credit worthy, stuff like that.
okay,
All it is just a story. You know, after my kids get everything, God forbid they predecease, they die before they get their full inheritance, their kids would get it. And so it tells a story from my death to the distribution to the last beneficiary. That's all a trust is. There's different kinds of trusts, revocable. I'll turn it over to John and he can kind of.
So a couple things to keep in mind with trusts. Revocable trust Brian was talking about. Very similar to your will, because it says who you are, who your beneficiaries are, who's supposed to get it, how much they're supposed to get, when they're supposed to get it. Your will says that a lot of times too. As a matter of fact, you can have trusts under your will. The reason some people don't is because your will get probated, and so they're trying to avoid probate. But think of a trust as very much like a will. It tells a story, like Brian was saying. It says who you are, who you're married to, who your kids are. You know, it talks about your assets. You might have a family business. It may talk about that. But it basically sets forth everything your will sets forth. But it avoids probate. Okay? So the other thing I'd tell you is make sure when you get your estate plan done, everybody thinks if you're an attorney, you know how to do estate planning. That's not true. They can go out and find a form on the internet maybe, but I'd advise against that. If you're going to use an attorney for your estate plan, find somebody that specializes in it, like Brian, or somebody similar to Brian. Because there's all sorts of attorneys out there. There's some that specialize in criminal law. There's some that specialize in divorce law. There's some that specialize in mergers and acquisitions of businesses. I mean, there's all sorts of different types of specialties. But if you're going to have an estate plan done for you, don't just go to some Joe Blow attorney who doesn't specialize in it, because you're going to get what you pay for. I'm just telling you. And I've seen problems with it over and over again. Not 100% of the time, but a fair amount of the time. So you might pay a little bit more, but you're going to get the product that you want. So I would tell you that. Like Brian said, there's trusts for everything. I mean, there's a special needs trust he talked about. There's charitable trusts. If you want to set up a trust for your church or your favorite charity, there's irrevocable trusts, there's revocable trusts, there's a trust for everything. There's pet trusts, there's gun trusts. You can set it up for just about anything. But there's a lot of types out there, but the most common one is a revocable trust. And don't be scared of that, because you retain complete control. While you're alive, you control everything that happens with that revocable trust. Yeah.
Got a question on a land trust. We know some people that set up a land dynasty trust for
Yep.
family benefit. Can you speak to that a little bit?
Sure. So he asked about dynasty trusts and land trusts. Dynasty trusts are set up so that potentially they can last forever. Like you could die and it could go on for 100, 200, 300 years. Now some people may say, well, that's ridiculous, that's not necessary, and it might not be. But there are some people that feel like with land, like a farm, maybe a family farm that's been owned by the family for 3 or 4 or 5 generations, they're saying, we don't ever want that to go to somebody else. They might set that up in a dynasty trust so that it never gets sold and that it continues to benefit beneficiaries from that family, from the children to the grandchildren to the great-grandchildren to the great-great-grandchildren to the great-great-great-great-great-great-grandchildren. I mean, it depends how far you want to control it. But that's what a dynasty trust is. And it stays irrevocable, you know, it doesn't get changed, and the terms kind of stay put, you know. And we have trusts like that. But we also have trusts where they just say, you know what, I can't control anything past my grandchildren. I'm just going to take care of my children and my grandchildren, and then hopefully they take care of their children. But there's trusts for everything, and you can set them up kind of however you want, as long as they don't break the law.
A dynasty trust that we're doing that was drafted in 1905. And it's gone from 5 kids to 100. And what it does is it provides, remember I said health, education, maintenance, support? That's called HEMS, H-E-M-S. It just takes care of every generation. Warren Buffett said, leave your kids enough so they do something, but not so much that they do nothing. And that's a trust fund baby deal. And, you know, there's a trust for Leona Helmsley, the Queen of Maine. Her nephew is in town here, huge. I don't know what he's given a ton of money to various, I think he was just in the news a couple of weeks ago. Oh, here's $2 million. She had a cat trust, because that's pretty much all that she loved. But he's around here donating a lot of millions. I can't remember who the last lucky crew was that got it.
I'll tell you one more thing.
Goes to with what Brian said, you know, give them enough, but not too much. We take care of a lot of trusts, and we take care of a lot of beneficiaries. And sometimes there's so much left to the beneficiaries through the trusts that there's no incentive for those beneficiaries to ever get a job or to go get an education. And they don't really become productive citizens of that community. So what sometimes people do is they'll say, if they go and get a 4-year degree, or if they get a college education, then they can have money distributed to them. Or they might say, it might be an incentive clause that says, pay them 50 cents on the dollar or pay them 100 cents on the dollar per their W-2, so that you make sure they have a job. Okay? So I mean, I see stuff like that. And, but I also see beneficiaries who have never worked a day in their life. They're spoiled, rotten, and they're never going to change because everything's been given to them. You know? I mean, they're not everyone's like that, but I mean, those are some of the issues that we confront when you leave a fortune.
30 years ago, an old client of mine, loved her. She came down with emphysema. And she had one son, his son predeceased her. She had a daughter that was a vet student at U of M, came back here, was a vet. And she said, hey, I've got emphysema, I'd like to be a grandma before I die. He said, I'm busy dealing with cats and I'll get around to it and everything. And she had me draft this, and this is like the heightened incentive trust I've ever drafted. She said, I want you to put, she's worth about $6 million. And she said, I want you to draft a trust that said, upon my death, if my daughter has issues, she gets everything. However, if upon my death, my daughter has no issue, she gets half and the rest go to my nieces and nephews. And I got it drafted up. She said, I want you to send it to her. I said, she's going to kill me. And so I sent it to her, and the girl called me back, says, are you serious? I said, your mom's dead serious. And she had 3 kids in like 12 minutes. And so mom got to see her grandkids, 2 of the 3 before she died. That's an incentive trust. You've also got an incentive trust, stay in school. I've got one, I never know how it turned out. My client said, I got a bunch of loser kids. They've been doing drugs, drinking, all this stuff all their lives. When I die, they have to take a UA. Don't tell them. They have to take a UA. If they're positive, they get nothing. And it's in the will. And I don't know how that ever turned out, because I don't know I think she might still be alive. But trusts and estate plans are specifically tailored for your family situation. If you've got a kid that's in and out of jail, or whatever. It might be an incentive trust, give them a certain amount of money. Or if you've got a kid that is a spendthrift, blows all his money, you might want to give him, you get 25 cents for every dollar you make. It's just up to you, and that's what you develop. Can we have the next slide? Do you have anything further on that, John? No. We talked about the living trust. You can change it any time you want. The only time it becomes irrevocable is when you die. You can change it any time you want. You can put incentive provisions in there. You can say whatever you want in the trust. Next slide, please. Same thing. It tells a story. That's all you gotta know. It just tells a story how I want stuff handed out to the very last beneficiary. Next slide, please. Things that are put in trust, and John was talking about titling, and this is important. When I'm Brian Kirby. I've got whatever named in Brian Kirby's name. If I establish the Brian Kirby Revocable Living Trust dated September 15th, 2021, that's the name of the trust. If I want to put, all right, what controls ownership of your house? Here's my keys. Does that control ownership of my house? What'd you say? So how do you show ownership of your house? What do you provide? Your deed, right? So you change it from Brian Kirby to the Brian Kirby Revocable Living Trust dated September 13th, 2021. That's in your trust. Bank account. You go to Core Trust, you change the bank account. You don't have to have your check bank say Brian Kirby Trust. You call Tim Pertington there or John. You say, I want to transfer this account into my trust. Your cards, unless they're collectibles, I don't really think about it. Any other investments you have, your brokerage account, it names that. It's in your trust. So when it's in your trust, it's not probated. Remember we talked about that? When you have things like contracts, like insurance, IRAs, things like that, they're not probatable because they're contracts. Trust, if the assets are in the trust, it's not probated. Well, you think, not to confuse anything here, but you have your trust. And I also have people set up a pour-over will. What's a will? Again, you appoint the personal representative and so on. And so what it says in there, it says, upon Brian Kirby's death, I hereby appoint Bob to act as a personal representative. He pays all my last illness expenses and death expenses and so on. The rest and residue of my estate shall be transferred to my revocable living trust. What's that do? That captures any assets that you forget to put in the trust. That might have to be probated, but the end result is it goes in the trust.
I always pick as a picture, if there's assets that don't get in the trust, they've spilled outside that pot of trust assets, so the will just takes them and puts them in there. So it's kind of a safety net almost. So a lot of times if you do a revocable trust, you'll also do a will. It'll be a pour-over will. And you'll also do a durable power of attorney. There's multiple documents you'll do when you do an estate plan. If you go to somebody who knows what they're doing. If you go and just say, I want a will, and they say, oh, here you go. They probably don't know what they're doing. I mean, because they haven't talked to you about all the other types of documents you should have when you do a complete estate plan.
I had a client that had a trust, and he died many, many years ago. And one of the heirs kept getting notices from this unclaimed property thing. And they kept thinking, what is this? Dad died, 20 years ago. He had some oil stock in Georgia worth 6 figures. It wasn't in the trust. So they had to reopen the probate. The personal representative took over that estate, because he was personal representative of the executor, got that company to give him the stock, then that stock was transferred into the trust. That's the pour-over part. It just protects you. It's like dovetailing. You cover all your different angles.
Something that's very common for people in Sioux Falls is we're close to the border of Minnesota and Iowa, right? A lot of times I see people that have property in multiple states. They might have been a farmer in Minnesota and they retired in Sioux Falls because we don't have any state income tax or something like that. but they have assets in 2 different states. Well, one of the other cool things about a revocable trust is if you put the assets from the South Dakota and Minnesota into that trust, you avoid 2 probates, one in Minnesota and one in South Dakota. Some people have, because we live close to Iowa, Nebraska, if you go down by Sioux City, it's Nebraska, Iowa, South Dakota. We see a lot of people that have property in 3 states.
They might have a vacation home in Arizona or Florida. They put that in there. It's just, that's where my point is, I'm not trying to overburden you, just kind of feed your desire to learn about this stuff. And you write these notes down and you talk to a lawyer and you figure out what's right for you. Next slide, please. We're getting close done here. We talked about the federal estate tax, federal gift tax. Next slide, please. Unlimited marital deduction. I'm a 4th generation lawyer, and I remember my dad telling me when, I think it was the 70s, if you were a husband and wife, you had a $125,000 exemption for your spouse. That's all you could give her. Who's the idiot that thought of that? I mean, you light the same candle, but you can only give $125,000. Then they changed it to an unlimited marital deduction. And so when the husband dies, you can have $1 billion and give it all to the wife, no tax. Problem is, the estate plan, what's going to happen after mom dies? So the unlimited marital deduction, you still have to look at the tax situation. We talked about the portability. Next page, please. Elective share. You can't disinherit your spouse. Like in Missouri, you can sue on breach of a spousal contract. In other words, if someone dies and they disinherit the spouse in Missouri and a couple other states, you can sue the estate for breach of a spousal contract. In other words, you've been married, you're expected to share things. We don't have that. What we have in South Dakota is what's called the Augmented Estate and the Elective Share. If you disinherit, you say, upon my death, my spouse gets nothing, it all goes to my kids. Based on the length of the marriage, if it's 15 years or more, the disinherited spouse can elect up to 50%. It gets to be complicated calculation, but that's basically what it is. That's what the elective share statute's for. Possible exceptions, pre- and post-nuptial agreements. If you set up a prenup or you set up a postnup, you waive any elective share because you're saying, hey, I've got these assets for my kids, you've got your assets for yours. Anything we commingle is fine. You might jointly buy a house and you set that out, but you waive that part if you die. Next page, please. Advanced directives. This is where we're talking. Advanced directives, you flip the words around, it means you're giving directions in advance. There's 2 different types. John may have a difference of opinion, but I have never in my life drafted a living will. They were both formed, living wills and durable powers of attorney were both formed in 1989. I like a durable power of attorney better because all a living will says is, I, Brian Kirby, love life to its fullest, hereby state that I don't want to be kept alive. And you sign it. The problem with that there's nobody there with legal force and effect to enforce my wishes. Next slide. The durable power of attorney is it. You die once, you have an estate plan. My grandmother lived at Prince of Peace for 20 years. You could be incompetent for forever, for a long time. And you need to have what's called an advance directive, given the directions in advance. I would appoint my daughters, one after the other, successors, to handle 2 different things. Financial durable power of attorney and health durable power of attorney. Health one first. When I look at durable powers of attorney, these are positions, who you appoint in these documents are positions of responsibility. If you have a soulmate that's your son or daughter, that's a good choice for a healthcare durable power of attorney. And what that does is it allows your spouse, or your spouse first, then your kids, to speak on behalf of you if you are later declared incompetent by the court of competent jurisdiction or your physician. Now, the other thing is that I like about our durable powers of attorney is that you have 8 or 9 choices how you want to be treated. In other words, If there's no chance of reasonable recovery, I don't want to have life-sustaining treatments used. I want to be an organ donor, on and on and on. And you check these off. And what that does is that converts your durable power holder, your spouse or your kids, it converts their role from a decision maker to an enforcer. You know, you have a living will, you have to sit down with your family and say, you know what, I'm going to pull the plug on mom. You don't have to do that. With a durable power of attorney, it says, if I'm in this situation, I do not want to be kept alive. So instead of saying, I'm going to pull the plug, you say, I'm going to enforce mom's wishes. This is what she wants. I did it with both my parents. Doctors are on it. They understand, and it takes a burden off me. And it takes a burden off whoever is the power holder. With a durable power of attorney for health, like I said, you want to make sure you have choices down there. Everything, whether you want to be an organ donor to end-stage things like that. And it allows your durable power agent to get second opinions, change hospitals, doctors, all that stuff. The financial durable power of attorney has become more codified. And I'm sure you have that same thing at Core Trust. This is how the banks want the financial power of attorney to read. That gives your power of attorney all the stuff they need to do, and you can limit their powers. It allows them to pay bills, access accounts, all that kind of stuff. Those are, durable power of attorney are some of the most important documents on the planet. Like I said, you have a will, but even if you don't, the code plans for it. If you don't have a durable power of attorney, what are you going to have to do? You're going to have to get a guardianship. You're going to have to be appointed as a guardian, which is a big pain. I'm sure you guys handle as conservatorships, and you have to do annual accountings and all that kind of stuff. Did I miss anything on that?
I would just say, in my own experience, when my mom passed away 6 years ago, she had a stroke. She was basically brain dead. Luckily, I'd done a durable power of attorney for her. My brother and sister and I had a difference of opinion on to whether let her go or not. And the deciding factor was the power of attorney document that stated her wishes specifically. That was the only way my sister would give in. Otherwise, she was saying, keep her alive at all costs. So it's really important to have that as part of your estate plan.
And that's the whole key is you're telling your kids what to do so they don't kill themselves. That's your responsibility as parents, to let them know this is how I'm going to do. This is how I'm going to divide my estate. This is what you're going to do with me. And it allows them to cherish their life with you without killing each other, basically.
You didn't make the decision, we're going to let dad die or let mom die. They made the decision, and you're just following their directive. So you don't have to feel guilty about making the decision.
Next slide. We'll be done. I don't think you get any education credits for tonight, but did we answered all your questions? I know it's probably overwhelming at times, but all I want to do is just feed your curiosity, and you got something in your gut that brought you here, and hopefully we answered some questions. John, he has his business card on the left side, mine's on the right side. Call us anytime. Let us know what you think. If you've got any questions, go see your lawyer, go see whatever. And
Ryan, one other thing I wanted to mention about the trust. You know, like with a will, you determine who your personal representative or executor is. With a trust, you determine who the trustee is. And a lot of times you'll name yourself as the trustee, but then there's a backup or a successor trustee. Be careful when you name family members. If you have multiple kids, and let's say, I see this happen all the time. They name the oldest as the successor trustee. And so dad dies, now the oldest child becomes the trustee, and the other two have to stand to the side. A lot of times there is suspicions once mom and dad are gone that maybe the person in control is taking advantage. be careful. I know you think your kids, I mean, I like to think the same thing. They all love each other and they're going to get along for the rest of their lives. But when money's involved and assets are involved, sometimes that changes. And so if you don't want them to be fighting amongst each other and suing each other, saying he took advantage and took assets that didn't belong to him, or he spent more money than he should have, whatever, and then they are never friends again, consider a corporate trustee that's an objective party that's not related to anybody. It costs a little bit of money, but it might save the family's relationship. That's just my 2 cents, and I've seen a lot of family fights over my 30 years. That happens fairly frequently. The last thing I'm going to mention, anybody ever heard that there's a 50% divorce rate in the country? Yeah? Well, if you have a family business and you want to make sure that when your child marries, that part of your family legacy, your 4th generation farm, doesn't end up in a divorced son-in-law's hands, you might want to place it in a trust and give the income to the child, but don't give the asset to the child. There's a 50% chance. I'm just saying that's what happens in this country, is there's a lot of divorces. And so sometimes you can say, I'm not going to pass that asset to my child until they've been married for 15 or 20 years or 25 years or whatever the case might be. But that's also a very common issue that you see in this country. There's a lot of divorces. Trust can be very beneficial for that.
I've done that with businesses, do a prenup, postnup, and have the assets held in trust, just to protect it. Because mom and dad have been building this family business for 100 years and get it blown up because a couple of brats get divorced, and you want to protect it. And they get their income. If they're happy and they're married for 50 years, they get it. And I am all on having, I've been doing this 34 years, and it's hard enough to run our own lives. Then you got to deal with the finance. You've got to do the tax filings and all that kind of stuff. At the minimum, I try to have an institutional trustee or a court act as a co-trustee. So Johnny or whoever's in it knows the family dynamics. Oh yeah, I'll give her money. She needs a new car, all that kind of stuff. And court trust handles the finances. Says no. Johnny wants a Ferrari. No. I get an F-150. All right, fine. Stuff like that. And that is a huge saver. They're very reasonable. It's usually a base point, 1%, whatever, of the value of the assets. And they've helped my family tremendously. They've helped a lot of my clients keep from killing each other, making sure that the decisions that they make are solid. Any other questions? Yes?
Tell me what a skip trace is.
Skip trace, they go back and they look at try to do reverse calls on their phone numbers, try to track their phone numbers, they'll do, like my firm did it on me, and I was kind of scared. It was like this thick. Everywhere I've lived, everything I've done, and I just did it for a hobby, see where I've been. You get Alzheimer's, I figured out where I couldn't remember. But they'll check out everybody where they're at. And you've got to have mutual family, friends, or whatever who you want to give it to. They might be able to track them down as well. And you want to make sure they're still alive, too. You want to make sure they're still alive. Any other questions? Okay.
Various ones of our church have said from time to time, we should do an estate planning session. Okay. So it's taken a few years, but we've finally gotten it done. So recognizing this of human nature to put things off, you've got a little information about how you might get a start with some of this, and obviously there are all kinds of people that can help out there with things. These two gentlemen, Brian and John, have provided this information at no charge to our church this evening. You have no obligation to use them, but please do consider the information that they have provided you this evening as a good start, and of course, if you're interested in them helping you, give them a call. So let's give them a round of applause. And thank you for all your time.